Hello, everyone, and thank you for joining us this afternoon, for Richard Dvorak's civil rights case against the police and prosecutors litigating a Section 1983 Brady claim. This is presented by Illinois Legal Aid Online and First Defense Legal Aid. And just a bit about Rich. He is the owner of Dvorak Law Offices, LLC, a law firm concentrating in civil rights litigation and criminal defense with offices in Chicago and Willowbrook, Illinois. He is a former assistant public defender with the Cook County Public Defender's Office and is a member of a First Defense Legal Aid Advisory Board. He is also an adjunct professor of prisoner rights at Northern Illinois University. He's a graduate of DePaul University College of Law and has been practicing since 1999. With that, I will hand it off. Please take it away.
Thank you very much, Daniel. So thank you all for attending, and it's going to be a bit odd to not be able to see any faces I'm talking to, but I will do my best here to imagine all of you reacting positively to this. So anyway, I'm going to start then with just the basics of what this talk is going to be about, because I know that there are some people who are lawyers and some people are not. I'm assuming the majority are lawyers. Oh. Camera got off, sorry. Okay. And some of you do criminal defense, some of you do civil rights. So it's going to be fairly general, but also there'll be parts of it that are pretty specific to people who do practice in this area, and also people who practice criminal defense. So hopefully it encompasses all of those targets as well. All right, so this is a specific aspect of a civil rights case, called a Brady claim, and it's for violating the rights under Brady versus Maryland, a Supreme Court case from 1963. Okay. So I thought maybe when you're thinking about this, you could also think of Tom Brady for kind of memory purposes, because like the prosecution or like all the city of Chicago and all these people who are defending these cases in the civil realm, there's lots of resources, lots of good backup. They win 90-95% of the time, and occasionally they cheat. So your job is to discover the cheating, challenge the cheating, and then once you win the criminal case, to turn around and try to sue the police or the prosecutors because your client or the person may have been the victim of this Brady violation. All right, so let's start with the basics of Brady versus Maryland. So this was a death penalty case. It's strange we always talk about Brady in the context of innocence. Brady was not innocent. He did the murder, but what was withheld from him was a statement by his co-defendant admitting that he was the shooter, not Brady. So that went all the way up to the U.S. Supreme Court, and the holding was that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material to guilt or punishment, irrespective of the good faith or bad faith of the prosecution. So I underlined a few of those because it has to be suppressed by the prosecution, meaning if you have the documents, there has been no Brady violation. There's a little nuance on that later in the talk that I'll get to, but for now, if you have it, it's not a Brady violation. Has to be favorable to an accused, and that case law has developed a little bit later as well, and I'll get into that. It says upon request. That part of the case law ended up changing because Brady applies whether or not the defense requests it or not. And by the way, it says violates due process, so this is based on the Fifth Amendment due process clause applicable to the states through the 14th Amendment. And where the evidence is not material to guilt or punishment, or it is material, I should say. So materiality, that's another thing we'll get into during this talk. and then irrespective of the good faith or bad faith of the prosecution. So if it was an honest mistake, it's still a Brady violation for criminal purposes. We'll get into later that it's when you're trying to sue someone for a Brady violation, you do have to show some sort of intent, some sort of intent to do this, which we'll get into later. All right. The next major case from Brady was, I don't really know how to pronounce all these names, so I'm hoping I'm doing them right. Augers, I would say Augers, but I think that's probably wrong, from 1976. So this is where we changed that part of Brady that said upon request. So after this case, you don't have to request it to get it. Again, when I've probably been mispronouncing it, I always pronounced it Giglio, but I heard Judge Kennelly keep saying Giglio in a Brady hearing we had in December. So I'm assuming that Judge Kennelly is right, not myself, and it's Giglio, but I always said Giglio. Anyway, evidence favorable to an accused is equated to exculpatory material and includes impeachment evidence. So Brady applies. You don't have to be fully exonerated for Brady to apply, even if it impeaches a witness. That can be enough for Brady, as long as it's material, which we'll get to. Bagley was the next major Supreme Court case. Now this is where they further define what material means. So the Supreme Court ruled that evidence is material if it causes prejudice, okay? Which means the withholding of evidence must have resulted in a reasonable probability that a different outcome would have occurred without the Brady violation, which they further defined as one that undermines confidence in the outcome of the trial. Now, for some of you, especially who do criminal appeals, you may recognize this standard as the Strickland standard. So it's the same. So therefore, keep that in mind, because if you find a good Strickland case of ineffective assistance of counsel on an issue of materiality, feel free to cite that in a Brady case, and vice versa, because it's the same standard. There's a lot more Strickland cases out there than there are Brady cases. So expand your research on materiality to include ineffective assistance of counsel claims. Now, just to be clear, they say reasonable probability. So I think a lot of courts still to this day look at that word probability and think, oh, more likely than not, preponderance standard. It's your burden to show more likely than not the outcome would have been different. Not so. I'll get to that in a second. Kyles v. Whitney was the next case. This is where they talk about prejudice and materiality. By the way, my camera. It broke right before the talk, so I had to use tape. That's why it keeps moving. I always have to have technical issues. It was working fine just before, now it's starting to not work. Anyway, in analyzing the prejudice or materiality, courts must look at the evidence cumulatively in the context of the entire trial. Okay, so that means that materiality is not just looking at one little piece of evidence and decide, is it important evidence or is it not important evidence? Because that's going to depend on a lot of factors. The most important factor is, what's the strength of your case? I mean, if you have a case where a guy confessed on video, the DNA matches him or her, and they withheld some evidence, it's a bad thing, but it doesn't necessarily mean you're going to be able to prove materiality, because they're just going to say, you know, the strength of the case was overwhelming, and therefore you can't prove it's material. So on the other hand, if you have a very weak case, and even if the evidence was not huge that they withheld, you know, it's more likely to tip the scales in the favor of materiality. So A is you have to definitely look at the context of the entire trial. Okay? So I cited some follow-up cases here. Gowdy v. Basinger was one of them. And that's a Seventh Circuit case from 2010. Now, that case you'll see later, it's called Gowdy v. Cummings. And that's because Gowdy ended up being my client in the civil context. I did not represent him in the criminal context. I'm going to quickly tell you the facts of Gowdy because, you know, my case, I'm going to talk about it during this talk. So Walter Gowdy was charged with murder, along with, you know, 3 other people were in the car at the time, but there were 2 shooters, one on the passenger side and one on the driver's side. So Walter was, you know, identified initially, okay, because about a year after the crime, he walked into the same place that the murder occurred in Anderson, Indiana. And one of the bartenders or the workers there said, "Oh, I think I see one of the shooters." Next thing you know, he's taken to the police station, and I'm not making this up. A year after the shooting, they did a 1-person show up at the police station. So they didn't do a regular lineup. They just showed him through one-way glass and said, "Is this the guy?" Incredibly suggestive ID. Okay. So that was the initial evidence that connected him. Luckily, they couldn't find the second shooter. Luckily for Walter, even though he was initially charged, he had numerous alibi witnesses. So after a couple months of being charged, the prosecutor decided to drop charges. The lead detective named Cummings was not happy about that. Mr. Cummings, Rodney Cummings, happened to be a lawyer. He went to night school, become a lawyer, also a police officer. So he decided to run for district attorney against the prosecutor who dropped the charges. He won, and he then turned around and re-indicted Walter for the murder, where he was the lead detective. So they went with that as the prosecution, and one of the people inside the car, he was a witness for the state, and he testified against Walter and said, "Yeah, Walter was there. He was one of the shooters, and he did it, and I just, you know, sat by watching." Well, what Walter didn't know, because they withheld the evidence, was that that same witness who testified against Walter, the flipper, was identified by the other witnesses, the eyewitnesses, as being the second shooter. He didn't learn that until later. The way he learned that later was because right before Walter's trial, some new evidence came out where his brother, his half-brother, Romeo Lee, actually did the murder. Okay, Romeo did the murder along with Kaide Harvell, the state's witness. So he came forward and said, "I can't let Walter take this murder because I did it." Okay, can't make this stuff up. It's Hollywood. So Cummings, having not disclosed that Harvell was identified as one of the shooters, decided to just make Walter one of the shooters, and Romeo Lee use his confession and make him the other shooter, and continue to withhold the evidence that Kaide Harvell was the second shooter along with Romeo Lee. The way that he found out about this was that he found out that Romeo Lee's attorney found out during his trial, which occurred after Walter was found guilty. This happened in 1997, I believe. So they clearly had evidence in 1997 that a serious Brady violation occurred to Walter, and yet the Indiana courts did nothing about it. He lost appeal after appeal after appeal after appeal until finally he got to the Seventh Circuit. He did a pro se appeal. He was appointed a corporate lawyer, and the corporate lawyer got him off. Then he came to us and he sued for the Brady violation. So Gowdy v. Basinger, I'm going to talk about it a little bit later. That's why I went through the facts. So one of the things that comes out of the original appeal, which overturned Walter's case, though, was that you cannot look at evidence and dismiss it. Again, I'm probably mispronouncing this. I don't really speak Latin, but in seriatim, I think is how you say it, piece by piece. You can't look at this piece and whether it was material, and then go to the next piece and say, well, was this material or was this material? Because that's what the Indiana courts were doing. Okay. And instead, you have to look at how all the evidence comes together. And if there's more than one Brady violation, it's going to pile up on top of each other to create a better chance of materiality. Beeman versus Friesmeier, another Seventh Circuit case. You have to look at the entire record. Okay. The reason that is important is because you don't necessarily have to look to the trial record. If evidence wasn't introduced by the defense because of the withheld evidence, then you can include that in your materiality aspect of it. So you're not limited just to the trial record. It's the entire record, even things that weren't introduced. That's similar to what they said in United States versus Burnside, where they talked about evidence being the tip of the iceberg. Okay, so yeah, certain evidence was withheld, and that might have led to different evidence, which might have led to different evidence, which leads to the iceberg. So you got to think of all this kind of cumulative impact when you look at material. All right. Now, Weary v. Kane from 2016, this is where they clarified, I think it already was clarified in Kyle's, but they clarified it further, that it's not the preponderance standard. All you have to show is there is a reasonable probability that the withheld evidence could have affected the outcome of the trial. And that they made it clear that it's not even 50%, okay? Strickler versus Green. The reason I'm getting into this case was because they talk about there are three components of a true Brady violation. The evidence must be favorable to the accused, okay, exculpatory, impeaching, suppressed by the state, either willfully or inadvertently, okay, and that's for criminal purposes. And then the prejudice must have ensued. The prejudice is the same as materiality. Now, if you go to the Ninth Circuit instruction, then this is what the Ninth Circuit has for a standard civil instruction on proving a Brady violation. All right. These are the elements of a civil Brady violation under Section 1983. So the defendant, the particular defendant, suppressed evidence that was favorable to the accused from the prosecutor and the defense. The suppression harmed the accused, and the defendant acted with deliberate indifference to the accused's rights. The deliberate indifference part is unique to any civil aspect. You have to show that they intended or reckless in doing their actions. Unlike a criminal case, you don't have to show that. But that's in line with what the U.S. Supreme Court said in Strickland about the three basics of a Brady violation. Well, let's compare that. I apologize. I thought I had this ready for. thought I made it part of mine, but I guess I did not, so I apologize for that. But the Seventh Circuit has an instruction, okay, that is different than that, okay? So, back to my presentation. It's not on the screen here, I apologize. But the Seventh Circuit also, as an additional element, makes you prove that the defense could not have discovered this with due diligence, okay? So that's called the defense due diligence rule, all right? So in other words, what the Seventh Circuit does and what Illinois does and what about half of the circuits do in federal court is say, okay, well, I understand that we withheld this evidence, but you could have discovered it on your own had you just acted more thoroughly in investigating your case. And if the courts agree with you, okay, then there is no Brady violation, okay? And in the Seventh Circuit, that's something you actually have to prove. It's part of the element in the jury instruction. So it's called the defense due diligence rule, okay? I'm going to get that into a little bit later because it's really just a made-up rule. It is not supported by U.S. Supreme Court case law. All right. So one of the things and one of the reasons I like giving talks like this is I want to encourage all lawyers to challenge that. Okay. It is not in any U.S. Supreme Court case law that says that you have to use due diligence in discovering their withholding. Okay. Kyles v. Whitney. This is important because there's a difference between criminal and civil when you're talking about Brady. If it's a Brady case, it does not matter whether or not anyone tried to withhold evidence. If they withheld it, they withheld it. It also doesn't matter if it was the prosecutor who withheld it or the police officer who withheld it, okay? But in a civil case, it does matter. In a civil case, you have to show a particular defendant, whether it's a prosecutor or an officer, had the intent to withhold it or was reckless in withholding it, okay? And when it comes to the police officer, you have to show they withheld it from the prosecutor. And I'll get to that in a second. Okay, so these are some special aspects of a civil Brady violation. A mental state, which I have said a couple times, has to be either knowing, reckless, or intentional. The evidence must have been withheld from the prosecutor, okay? And that's from Beeman versus Friesmeier is one example of that. And then you have to get into the immunities, okay? Why is the from the prosecutor so important? And how does that relate to qualified immunity versus absolute immunity? Well, this is where it gets interesting. So if you're a police officer and you give evidence to a prosecutor, you're off the hook. That's all you have to do. Your only job is to give the evidence to the prosecutor. If the prosecutor withholds that evidence from the defense, that's on the prosecutor, not on the cop, even if the cop knows it's being withheld, okay? So it's really just an absolute defense, right? So in when you're trying to prove a case on a civil matter, it's going to be key to figure out if there was certain evidence was given to the prosecutor or not, because if they can prove that they got the evidence that was withheld, well, then you can't sue the police. So it becomes very important that at least if you're trying to sue the police, that it was the police who withheld the evidence from the prosecutor and not the prosecutor withholding it from the defense attorney. Okay, and why is it's really also key to get the police on the hook because of immunities. The reason is because police officers are only entitled to qualified immunity, but prosecutors, depending on their role, oftentimes are given absolute immunity. So qualified immunity you can deal with, okay? You can get around that, on certain cases. Absolute immunity you can't. If the court finds that they were acting in their role as a prosecutor, your case is over, done deal. And generally, courts have held for a long time that the tendering of evidence or withholding of evidence is a classic prosecutor function, and they're pretty much immune for that kind of action. So that's why if you have a case where the police gave evidence to a prosecutor withholds it from the defense, The police officers are going to get off because of the immunity freeze-Meyer, and they didn't withhold from the prosecutor. And the prosecutors are going to get off because they're going to say, well, we had absolute immunity because we're acting in our role as prosecutors. And then your client, or the victim here, gets nothing. Okay. So, all right. That's a critical aspect of a Brady violation. All right. So, how do we know if someone's acting like a cop or acting like a prosecutor? Okay. One thing that the courts have not said is that they care about titles. Just because you are a prosecutor doesn't mean you get absolute immunity. Okay. So you have to look at the role that they're acting in. All right. So there's some U.S. Supreme Court cases on this. Imbler is sort of the classic one from 1976. And that's, I'm not going to get too technical into that because we could have a whole talk on absolute immunity if we wanted to. But suffice it to say that things like holding a press conference, okay, that's just one example that they'll do. That's something that prosecutors, that's not in their traditional role, okay, even though they do them, that's not the traditional role of a prosecutor. But tendering evidence is, okay. What they've also said is if the prosecutor takes actions before the filing of charges, or even before the establishment of probable cause, okay, then they're more likely to act in their like a police officer, and then are subject to qualified immunity, not absolute immunity. All right. It gets really interesting in other aspects of it because sometimes prosecutors may not be part of the trial team. So if one prosecutor withholds evidence from the other prosecutors, that's one way to get around absolute immunity. There's also very complicated case law that I don't think has still been settled from Whitlock v. Brueggemann and Fields v. Worry, both Seventh Circuit cases that talk about the withholding of evidence while a case is on appeal or a post-conviction, okay, because that's not part of the traditional trial role, and that's one way to get around absolute immunity. But again, that gets extremely complicated, and that those opinions are about as clear as mud. So I wouldn't rely necessarily on that. That's going to have to be further developed. By the way, before I get into Gowdy, my case again, there's another U.S. Supreme Court case, Connick v. Thompson. Okay, and yes, that is Harry Connick Jr.'s father, who was this guy who, over and over in numerous cases, withheld evidence from people, including people on death row in Louisiana, and what the plaintiff in Connick tried to do was to get around absolute immunity, because these are prosecutors withholding evidence, and they're normally entitled to absolute immunity, is he tried to bring a Monell claim saying they weren't trained properly, okay? And Monell doesn't have immunities. But what the Supreme Court said basically was, nice try. If the actual prosecutors themselves who did this were still acting their role as prosecutors, then they still get absolute immunity. Okay. Gowdy v. Cummings. Now, the reason that Gowdy is very interesting when it comes to this absolute or qualified immunity versus absolute immunity, and whether evidence was withheld by the police or by the prosecutor, is because, remember, in Gowdy, Cummings was the police officer originally, okay? And what he did when he withheld the evidence was there was a lineup of Kaide Harvell, the witness against Walter, being identified by two states. I'm sorry, I think there were 4 states witnesses who identified him. I think 2 is the shooter and 2 is the not the shooter. I'm not sure, but multiple witnesses testified that he was the shooter. I'm sorry, the other people put him on the scene, but all 4 of them said he was there, and I think 2 of them said he was the shooter. And this was on video. He actually videotaped these lineups, and what he did was he put these videos in an evidence locker, okay, when he was a police officer. While he was running for prosecutor, knowing he was probably going to indict Walter, and he wanted to withhold this evidence, okay, knowing that if he tendered it, there'd be no case. So he took his original actions as a police officer in putting it in the evidence locker. Signed it, Rodney Cummings, with his police star number. Well, then he later on as prosecutor charges Walter with murder, and then he continues to withhold that evidence, okay? He never retrieved that evidence even while he was prosecuting Walter. And there was even notes in the file, that we got that said, videotape still missing, that kind of thing. So I think it was clear that he was withholding it from his own trial prosecutors, okay? Although that got complicated because it appears that they may have known that it was being withheld, but he was frustrating their attempts to get the video. Again, they're complicated facts. So really what originally the trial court held was that Cummings was entitled to qualified immunity up until the point that he was charged, Walter was charged, and then Cummings became a prosecutor, and so you can't get him in his role as a prosecutor. And we fought about that long and hard, and ultimately the court kind of backed away from that analysis, but still granted summary judgment based on other dumb reasons. And then we won on appeal in the Seventh Circuit. But this is what, now I say, is KISS our new savior? But keep it simple, stupid, okay? That is my new mantra for talking about suing prosecutors for Brady violations. Because normally it's very difficult. And if you get wrapped up in all these technicalities of, was there probable cause for the charge when the withholding happened? Was he indicted yet? All that sort of thing. I think you tend to lose, So, but here, what they ruled was, since finally Cummings argues that even when we found that the videotape was withheld, he is entitled to, part of my screen is cut off, but absolute prosecutorial immunity. The district court did not base its ruling on prosecutorial immunity, and for good reason. Cummings' actions, removing the video and hanging on to it for 14 months, had nothing to do with his prosecutorial responsibilities. He removed and retained the video in his capacity as a detective. Any entitlement to immunity that Cummings enjoys for his actions taken in his prosecutorial capacity after April 7th, 1995, which was the day of the indictment, is beside the point. Okay, so really what they said was he was acting like a cop. The actions he took is what cops do. Cops put evidence in lockers. Cops withhold stuff from prosecutors. Cops sign their names with a badge number on it. We had pages and pages and cases of briefing that was much more complicated than that, but we were trying to keep our arguments simple, and they ruled it was a simple thing. So I think what we need to do is, when we're looking at withholding of evidence, to kind of try to go beyond, okay, if a prosecutor does have the evidence in their hands, which is problematic, because that means it gets the cops off the hook, and normally you get, absolute immunity. See for creative ways of finding out whether or not, you can argue that what they were doing was more like a cop. Were they interviewing witnesses? That's kind of a lot of times what cops do. Although in some case laws, prosecutors do it too. In one of our pending cases, we have, a prosecutor who hypnotized a witness and then didn't tell the defense about it. And specifically, they hypnotized the witness because the witness didn't have a good enough identification. All right, but after the hypnotizing, they did. Important information the defense obviously would want to know. And we haven't briefed that issue, but they didn't file a motion to dismiss when we made that allegation. The prosecutor didn't. I think we got a good opportunity to say that hypnotizing witnesses is not something prosecutors do. Now, do I want to, go on those technicalities of, oh, was there probable cause to charge before that or after that? You know, that might be one other way of doing it, but I'd rather do a more basic thing. And the basic thing is, you know, that sounds more investigative, more police oriented than prosecutor oriented, you know. All right. By the way, another reason to show you how bad Indiana is, once again, I think I want to say in 2000 and I want to say 2012, but I'm not sure. Maybe it was earlier than that. After the client, his name is Max Sims, after he filed a pro se post-conviction and was appointed counsel, based on other things, it wasn't about, he had no knowledge of this, of the main witness was hypnotized. The new prosecutor handling the matter did the right thing. He had a conversation with the original prosecutor, who became a judge later, and the former prosecutor / judge told the new prosecutor, don't tell them that the witness was hypnotized. He tried to get the new prosecutor to continue on with his misconduct. The new prosecutor said, no, I'm not having any of that. And he told the judge about what the guy did. You would think that would have resulted in a new trial immediately, right? Nope, not in Indiana. He lost the post-conviction, lost the appeal, lost the federal habeas corpus petition, and then it got to the Seventh Circuit, and he won. But by the way, I didn't do the criminal case, but I did civil. It wasn't even wasn't 2 out of 3 judges who thought that, though. There was 2 judges. One, Judge Bauer, said it was one of the worst Brady violations you've ever seen. Judge Amy Coney Barrett, though, who is the dissenter, apparently didn't think it met the standard. She actually said it met the standard of a Brady violation, but didn't meet the standard of the heightened habeas corpus clearly established Brady violation. Anyway, so even, you know, when you find this stuff, it doesn't mean you're automatically going to be released. All right, qualified immunity. Okay. So qualified immunity, like I said, is not too much of an issue because, you know, Jones v. City of Chicago, this was one of the leading or the first cases where they discovered street files being withheld. So many of you might know this, but the City of Chicago for decades had their own police files that they withheld from prosecutors. They called them street files. And the court said, no, that's obviously a Brady violation, and the officers who engaged in this, you know, could be sued. And no, they're not entitled to qualified immunity because all you have to show for qualified immunity is, was the right clearly established at the time of the misconduct? And they said, you know, Brady was decided in 1963. So, you know, qualified immunity is really never going to work for the police in the Brady context. In other contexts, it's horrible and the police do get off, but not in the Brady context. All right, so this is what I was talking about for the defense due diligence rule. So I previewed this before about, you know, I think the Ninth Circuit got this right, and some other circuits got this right, that you don't have to show that the defense attorney could have discovered it with due diligence. Okay, if something was withheld from the defense, it was withheld. It doesn't matter if the criminal defense attorney, you know, could have found the evidence or not. All right. And where do I get this from? Well, first of all, none of these, you know, Seventh Circuit cases or other circuits or Illinois, you're not going to find any that really have any basis in U.S. Supreme Court case law. There's some references to early 1970s, but it's complicated, but believe me, it's not very well based. But clearly in 2004, in Banks v. Dretke, the U.S. Supreme Court said a rule thus declaring prosecutor may hide, defendant must seek, is not tenable in a system constitutionally bound to accord defendants due process. Okay, actually one of my favorite Supreme Court quotes of all time. It's a great quote. It's a, you know, this is not hide and seek. You know, the prosecutor has to give this stuff to the defense. And then if that wasn't obvious enough, also from that same decision in Banks, it says Brady obligations are, quote, external to the defense. Okay? So if a prosecutor's Brady obligations are external to the defense, it means that the defense has no role in this analysis. Okay? You violate Brady by withholding evidence. You don't get off because the defendant didn't discover the withholding. It's something that is really bothersome to me because there is half the country or more where, including in Illinois in the Seventh Circuit, where defense attorneys are having to prove that you couldn't have discovered this with due diligence, and there's no basis whatsoever in those laws. I did write an article about it that I'll show you at the end if you want to research this further. But please raise this issue if you get this. Don't concede that the defendant must exercise due diligence as a proper defense. Okay, please challenge this from the beginning. Although that said, I did have 2 opportunities to raise this in 2 of my cases, Brady cases. One is currently in front of Judge Kennelly and one on the Seventh Circuit in Gowdy, and I chose not to. And the reason I chose not to was because our briefs were already so packed with stuff, and I didn't want to muddy the waters by trying to seek them to address this real hot button issue that would need to be fully briefed, that reversing precedents. It was a strategic decision that I thought it'd be better to focus on what I needed to, because there was no way they were going to ever say that this evidence could have been discovered through exercise due diligence. So I wasn't afraid of losing on that basis anyway. So challenge the rules of play the game. Again, if you guys can start challenging this, great. In the meantime, you got to deal with the existing case law in the Seventh Circuit of Illinois that does say that you have to show that you couldn't have discovered it with due diligence. This is just an example of Boss v. Pierce. I'm not going to read the whole quote to you, but that and Jimenez, the basic gist of these cases are that you don't have to show that, let's just say they have a witness who has exculpatory, evidence, and they didn't give you a summary of their testimony. Well, you have no obligations to what they call discover what's inside a witness's head. Okay, so you can find plenty of case law that really narrows the defense attorney's obligations here, and these are 2 of the cases. But there's some cases though where they say, hey, if you could have gone to a publicly available court file and discovered this evidence, then that's not exercising due diligence. Or if you could have subpoenaed materials that you knew about but didn't. There's going to be some hurdles in the current existing law, but for the most part, courts have really narrowed that defense, so to speak. Okay, let's talk about some practical considerations. One question is state versus federal. Brady is only something that you would be able to raise in federal court. It's in Section 1983 for violating your constitutional rights. You wouldn't be able to in state court, but in state court you'd have, the tort of malicious prosecution, or sometimes intentional infliction of emotional distress, and certainly the withholding of evidence is certainly relevant to a malicious prosecution claim. Okay. So it shows malice. It sometimes gets rid of probable cause, that sort of thing. There's lots of reasons why people might want to go to state court versus federal court. Jury pool is probably better in Cook County than in federal court, although it's getting better in federal court. There's no such thing as qualified immunity or absolute immunity. I shouldn't say that. For malicious prosecution, I believe that prosecutors are immune for that, but it's not based on federal immunities. So depending on the case, immunities might be at issue. Another thing is, was your client convicted or exonerated? So, I had a case, for example, that, the client, she was stopped on a DUI case, and she indicated that she was sexually assaulted by the police officer, and she made a complaint against the police officer. They investigated it. They did some testing of her underwear and his underwear, although I did not know initially that they tested his underwear. But her underwear came back, and his DNA was not on her underwear. So they not only didn't charge the police officer, but they charged my client with making a false police report, federal disorderly conduct. And then they were going to go to trial, accusing her of lying about the rape against the police officer based on this DNA result. I was still going to go to trial because this was a fairly quick situation, that she never said it was full-on penetration, anything like that. There's plenty of reasons why his DNA may not have been, in her underwear. And in the process of this, I did a request for 417 materials, which are DNA materials, very technical stuff that prosecution must tender pursuant to Illinois Supreme Court Rule 417. I really wasn't planning on having that turn up anything significant, but I just did it sort of as a matter of course, ask for everything. And then as I'm preparing for trial, I see that there's a lab report in there that says that actually, her DNA was in his underwear, okay, which was a report that I never got as the defense attorney, because I do criminal defense and civil rights. So they immediately dropped charges. And then I referred it out to a different lawyer. First of all, it was Kankakee County, so you have to file it downstate. He was more familiar with downstate. And also, too, I was potentially a witness as a criminal defense lawyer, so I referred it out. And they actually won a motion to dismiss on this issue. There's a whole body of case law that says, well, if you discovered the Brady evidence before trial, there is no Brady violation, because Brady only deals with withholding evidence at trial. And since there was no trial, you cannot sue for Brady if charges were dismissed. You caught him red-handed before trial, okay? Currently, because of this case, Bianchi, that is pretty much the settled law in the Seventh Circuit, that if this was ended up, now if in the traditional case where your client is exonerated later, after trial, then that's not a problem, bring a Brady claim. But if you do have someone who is, you caught the Brady and was found not guilty or dismissed without, without the Brady coming out later, then you have to deal with this Bianchi decision. There's more U.S. Supreme Court cases, Manuel versus City of Joliet and McDonald versus Smith, very recent Supreme Court cases that I think call into question Bianchi, because I think the Seventh Circuit is sort of at odds with the way U.S. Supreme Court looks at these cases. I think the U.S. Supreme Court has basically inferred that there's such a thing called a federal malicious prosecution claim under Section 1983. And if there is, it doesn't matter if you were convicted or not, okay? And I think under that logic, it shouldn't matter if there was Brady, if there was a trial or not. I also think, if you can show specific damages apart from a trial, I mean, if you can show that you wouldn't have been indicted or you wouldn't have been held for a couple days before you bonded out, I mean, that's a real harm. It's a damage that resulted from withheld evidence, even if there wasn't a trial. So, those are ways around that, but those are some of the considerations that you have. Practical considerations on discovery requests. In both the criminal and the civil context, request any and all, be as broad as you can, but also make specific requests if you think that there's something specifically, because otherwise prosecutors are just going to sort of give you what they have versus looking for things. In the civil context, do request to admit. Certainly send off subpoenas to other agencies. That's sometimes a good way of discovering withheld evidence. Define the files. Okay, so in a civil context, you want to establish what was the criminal defense file, what was the police file, and what was the prosecutor file. Okay, and that's not always easy to do, because sometimes they'll give you just a lump of documents. You have to make sure that they tell you, okay, pages 1 through 1,000, that was the police file. Pages 1,000 to 2,000, that was the prosecutor's file. And then the defense attorney, you'd probably have to get from the public defender's office or the private attorney, you know. And then you got to compare all three files, okay, to discover, okay, what's in the police file? Did that make it to the prosecutor file? What's in the prosecutor file? Did that make it to the defense attorney file? So define the files and then compare. Consider an expert. If you're on a civil case, especially if you can get someone who is a former prosecutor and a former defense attorney about, you know, what evidence, you know, is typically tendered, what's normal, you know, what evidence is material. Using the actual defense attorney sometimes is very helpful. You know, oh, had I known this evidence, I would have been able to argue X, Y, and Z. Okay. But sometimes an expert's able to say that too, especially if maybe the defense attorney has died, or maybe the defense attorney did a terrible job. You may not want that person up there, you know, saying what they would have done with the evidence if they didn't do a good job with the evidence they had. So consider an expert, defense attorney, maybe former prosecutor in a civil context, and also consider getting the actual defense attorney or attorneys to explain why, A, that they never got certain evidence, and B, why that would have made a difference. In depositions in the civil context, make sure that you establish the chain of custody. Okay, just sort of what I was saying before with defining the files, you know, where did all the evidence go to? Think outside the boxes. Okay, what that means is Brady is not always about what's on police reports or in lab reports or pieces of paper. Brady is often about what's not in the boxes, okay? What's not in the police reports. So if you can interview a witness, for example, and the witness tells you something that's helpful to you. Oh, you know what? I really didn't get a good look at the shooter, okay? But that's nowhere in the police reports, okay? Well, the first thing you have to say when you interview that witness or depose that witness is say, oh, and when you didn't get a good look at the shooter, you told that to the police officer investigating it, right? Detective Smith, right? Oh yeah, I told Detective Smith that, okay? Well, now you just established that Smith knew that and should have put it in his police report, okay? And then you get the police officer to say, no, had this person told you he didn't get a good look at the shooter, you'd have put that in the police report, right? And then you would have been obligated to give that to the prosecutor, and the prosecutor would have been obligated to give that to criminal defense, right? And you would agree with me that would be helpful information to the defense, right? And then it just becomes a credibility issue of, do you believe the witness or do you believe the cop that he told the police officer this information, okay? Witness order, the opposite is sort of what I just said, but witness order, what that means is quite often if you're doing a civil case, you may want to wait to have the trial prosecutors go last, or at least close to last, in order. Because as you take depositions, you're going to find out that might be more Brady material that you knew when you filed the case, okay? Because ironically enough, our powers to discover things in civil context are much greater than the criminal context. So all this new stuff that comes out during the civil depositions, you can then ask the prosecutors towards the end, oh, you didn't know this, did you? You didn't know this, did you? You weren't given this information, were you? But if you take the prosecutor's step first, you'll be robbed of that opportunity. Okay, so back to our nemesis, Tom Brady. So how do you defeat Tom Brady? Relentless defense, okay? So that means starting in the criminal case, if you're doing it on the criminal end. When I say first rule of Fight Club, definitely talk about Fight Club, okay? Prosecutors have affirmative duties to disclose evidence, okay? So those of you who do criminal defense, you'll probably have been in this position. Judge, I really want the prosecutor to get me, you know, X information, okay? I'm making a motion for discovery for that information. And the prosecutor will say, oh, we don't have that information. And then the judge will say, counsel, they just said they don't have it. You know, that's not what Brady's about. Okay, Brady's about affirmatively looking for the evidence that you have and affirmatively telling you one way or the other whether they have it. Okay, I cannot tell you how many times I've heard that excuse, and then the prosecutor comes back and magically that's the stuff that you wanted. Okay, but a case called Dennis v. Secretary of Pennsylvania Department of Corrections is called Dennis from the Third Circuit, 2015, says that in case you need a cite for that. By the way, if you are doing a Brady case, Dennis is probably the best Brady decision I've ever read in my life. It's an en banc decision. It's got multiple concurrences. It also talks about the fallibility of eyewitness identification. It's really an amazing case. Okay, it's a tour de force of Brady. I highly recommend reading that. It's a very long opinion, but it's amazing. Okay. If there is something that you need to find, I'm sure it's in Dennis. Okay, I cite it all the time. Second rule of Fight Club. Oh, so by the way, when I say talk about Fight Club, what it means is don't just have these discussions about your discovery fights, among the prosecutor and yourself. Have it in front of the court. Make a record of it. Okay. And same thing in the civil context. Okay, and make a record of it if you're having disputes about things. Second rule of Fight Club is win. Okay, Heck versus Humphrey. Again, I could do a whole talk on Heck versus Humphrey, but it basically means if you lose the criminal case or your conviction has not yet been overturned, you cannot file a civil lawsuit. Okay, so for Walter, for example, when Walter got this evidence, in 15 years before he actually was exonerated, 14 years, whatever it was. He couldn't go to federal court immediately and say my Brady rights were violated. No, you have to first go through the ridiculously incompetent Indiana court system and spend another 10, 12 years in prison, before you can get your rights heard in federal court. Unfortunately, that's the system. Okay, but you have to win first. Okay, before you can go to federal court. Here are my resources if you wanted to research any Brady issues further. My favorite book is well, not my favorite book, but my favorite book on Brady is called The Brady Book. That is the website right there. It's got a wealth of information. It's mainly quotes from case law, but it's, you'll definitely find something there. This is my article, Is Your Federal Circuit Woke? It's in the Civil Rights Litigation and Attorney Fee Handbook from 2019. It goes through circuit by circuit, which one requires the defense due diligence rule and which ones don't. And sort of a history of where courts have baselessly found this defense due diligence rule. Or just call me, visit my website, email me. I'd be happy to answer any questions, provide resources, provide examples, that kind of thing. So with that, let's see if I timed it right. 1:15, I guess so. I can take 15 minutes of questions and I'll keep adjusting my camera accordingly. Thank you.
Thank you, Richard, for that talk. Everyone, please, if you have questions, points of clarification, anything like that, go ahead and ask them in the questions, put them in the chat, things like that. To start out, there's an inquiry. Could you talk a little bit more about the deliberate indifference standard in this particular context? Is that often a difficult issue when you encounter it?
Generally, no. So deliberate indifference is basically the same as recklessness. Okay. So I think the only time so what I said before was either you could do it knowingly, like knowingly withheld the evidence, intentionally withheld the evidence, or recklessly for deliberate indifference. Okay. That's actually the lowest standard that you have to meet. Where that may come into effect is, for example, in the Gowdy case, no one kept records of what was tendered and what wasn't tendered, okay? And it was ridiculous because they had this rule in Indiana that says police reports are considered work product. Okay. So therefore, the defense doesn't need to get police reports because they're a work product. Okay, it's the most ridiculous thing I've ever heard in my life. I deposed 3 attorneys, including the attorney who argued it in front of the Indiana Supreme Court. He could explain it to me. It makes no sense because they all acknowledge that you do have to give witness statements. You do have to give Brady material. So how you're going to do that by not giving police reports, I have no idea. But anyway, because of things like that, you know, oftentimes they were all pointing fingers at each other. You know, the one trial attorney said, no, I wasn't involved in the discovery dispute. They were. They said, no, that person was. Oh, no, he was in charge. I mean, you know, so that's where it comes into effect when they try to blur the lines of who's responsible. If you can just say recklessness, like you went to trial not knowing, you know, what discovery was tendered. You went to trial not making sure that, you know, these receipts were signed off on. I mean, that's where it comes into effect. But if it's the police not giving it to the prosecutors, that's pretty easy to show usually because you'll have a police file and you'll have a prosecutor file, okay? And if it's in the police file but not the prosecutor file, we know that the police withheld it, and then it's just a matter of who withheld it, okay? And if your name's on the police report that was not tendered, you know, good chance you're the one who did it. Although in some cases, you know, you have a particular liaison person who is the point person between the police and prosecutors, and the person who wrote the police report may say, well, I thought he did tender it. He's in charge of giving it to the prosecutors, not me. So yeah, it can be a challenge, but I've never really encountered that to be an issue in practice because usually you know who did withholding. Usually it's a lead detective or detectives. So it's usually pretty easy to show that they either knowingly did it, intentionally did it, or recklessly did it.
And so we've got a couple comments and then another question. One person suggests that the group of attorneys who are well known to discover exculpatory evidence should be known as the Brady Bunch. I thought that would we would share that in spirit of you know, not being able to see the audience and laughs and things like that. There's a question about your reference to the movie Fight Club. Is it specifically to the movie, or is that any language out of a case?
No, that was just my attempt at humor, I guess. So no, and there's no cases that reference that.
And then someone else appreciates the fact about Harry Connick's dad and suggests that there should be a documentary about this. Don't know if you're aware of one. Is there one?
That's an interesting issue. I know 60 Minutes did something on him. I think if you go, probably if you go on YouTube, you'll probably find a 60 Minutes episode on it. I'm pretty sure they did it. Yeah.
Another question relates to the intersection of Manuel, McDonough, and Brady. If you could, you know, share your thoughts on that a little bit more.
Well, okay. So you have to know that from the Seventh Circuit before Manuel, they had this rule that basically said, well, when you are arrested up until the point of the Gerstein hearing, so a period of usually 2 days, that is a Fourth Amendment arrest. Okay, so if there was no probable cause, you could sue for those 2 days. Okay, but after a judge finds Gerstein, okay, really up through trial or past trial, then the Fifth Amendment kicks in, and now we're talking about your due process rights. Okay, and essentially what they said, you know, for forever was because it's based on due process principles, you have to show that there is no state law remedy available for you based on due process law. And because Illinois has the state law tort called malicious prosecution, you're out of luck. And for the time you had after your arraignment, you can only seek damages under state law principles, you know, malicious prosecution. So forever, you know, you would, when someone was found not guilty, you would bring or exonerated, you bring a Fourth Amendment actually, you wouldn't even bring a Fourth Amendment violation because they said that, anyway. You would bring your like Brady claim, for example, and then you bring your state law malicious prosecution claim for that time period. But in Manuel, the U.S. Supreme Court said, no, the Fourth Amendment can be violated even after that Gerstein hearing. Okay? And if you are held for 2 years pre-trial and there's no probable cause for that, you can sue under the Fourth Amendment for that. Okay? Now, what does that have to do with Brady? Nothing directly on point, but in McDonough, they were analyzing a Second Circuit way of looking at things. And the way the Second Circuit looks at it is, not only is there a Fourth Amendment violation when that happens, but there's a Fifth Amendment violation on something called malicious prosecution. And therefore, you should be able to sue under the Fourth and the Fifth Amendment for cases even when you were found not guilty, right? So to me, I don't know how that really complies with the idea that you can only bring a Brady violation if you went to trial, convicted, and then later exonerated. I think all those cases make it clear that the U.S. Supreme Court is going to say, no, anytime you are withheld or held based on no probable cause or based on withheld evidence, if you can show you're injured in any way, and I think, having to post bond, having to sit in jail, anything like that is an injury. I think eventually they're going to say, yes, you can have a Brady violation, even if you're found not guilty.
And I have a follow-up about that, which may no longer really be relevant so much, but regarding the rule about the inadequacy or the adequacy of a state law remedy that the Seventh Circuit was applying, are you aware of arguments being made related to the Tort Immunity Act's limitations on the statute of limitations for that type of claim in the context of rendering the remedy inadequate?
Oh, I see what you're saying. Well, put it this way. There was a case, and I forgot the name of it. It starts with a J, the lowest of the case. I'm blanking on the name, but it was a Seventh Circuit case out of Indiana. And this is before Emanuel, okay? And they made the same argument in my case, by the way. Indiana, you can sue police for malicious prosecution. There is a state court remedy, okay? The problem is that police officers are absolutely immune for malicious prosecution. So yes, it exists, but you have zero remedy for it, okay? So that went all the way up to the Seventh Circuit. Every single district court in Indiana, by the way, accepted that ridiculous argument that, oh, there is an available remedy because you can sue in Indiana for state malicious prosecution. Well, but you're immune for it. It doesn't matter, it's still available. I mean, it's the most ridiculous argument ever, but every Indiana federal judge accepted it, including my judge, until the Seventh Circuit said, no, that's ridiculous. If there is no realistic remedy, then no, that doesn't count for a state law option. So Indiana, so basically Indiana litigants from there on out were able to bring federal malicious prosecution claims, basically. So I don't, if you're saying how does that, if you can show, I think that the state Tort Immunity Act somehow limits your state remedy, and you're talking about a due process violation, I could see that same argument being made, sure.
There is a question, you were talking about witness order in terms of depositions. Could you elaborate on that a little further?
Yeah, so generally, when you're doing, getting on my camera, generally when you're doing depositions, the traditional order is plaintiff first, defendant second. And I say defendants meaning the main defendants, okay? And if you're suing a prosecutor, the thought is, okay, defendant, prosecutor among the first as well. I guess what I'm saying is you may want to mix up that order in a Brady case. And specifically, I think you may want to take the witnesses first, the eyewitnesses. because you may learn stuff during those depositions that you did not know, even though the person, was found not guilty or had his case overturned. Who knows what kind of shenanigans, they pulled, that they withheld even during the criminal case, even after, even in post-conviction proceedings. If you can learn all that stuff first, and then essentially confront the police with it next, and then confront the prosecutors with it after that, that's kind of an effective way of making sure you can kind of prove up your Brady, if that makes any sense. Now, on the other hand, it is kind of convenient to take the police officers first, because then you learn their defense. So it's not a hard and fast rule. I'm just saying consider witness order in these cases.
And before we wrap up, there's one person with their hand up. I don't know if you have a question or if it's just something that's going on with the program, but if you do have a question, drop it in the chat. Otherwise, we will conclude with many thanks to our presenter, Richard Dvorak.
Thank you all for coming. I appreciate it.
Awesome. And thank you everyone for attending. I will be uploading this to YouTube later. So for those of you who need a refresher or just want to watch it again, just for your own knowledge sake, it will be on our YouTube channel. And we can link it out to you after the show. So thank you everyone for attending. All right. Have a good day, everybody.
Thank you.